everyone to today's webinar on Disability Rights Michigan Litigation Update. With us today are two attorneys from Disability Rights Michigan. We have Nick Gable and Kyle Williams. Also with us is facilitator Marianne Huff, CEO and President of the Mental Health Association in Michigan. If you have questions during this time with us, you're welcome to drop them in the chat, or you can save them till the end when we have time for questions. Here's a little bit about our attorneys who are with us today. Nick has been a senior attorney at DRM since December 2021. Before that, he was an attorney for around 7 years at Legal Services of South Central Michigan, and he specializes in Medicaid litigation. Kyle received his law degree from Michigan State College of Law and has worked in private practice and municipal government prior to joining Disability Rights Michigan. He has been the Director of Litigation at DRM since 2019, and he specializes in civil rights and healthcare litigation on behalf of people with disabilities. Welcome, Nick and Kyle.
Thank you. Thank you, Kristen, for that introduction. And I want to welcome everybody today. Thank you so much for being here. Again, Marianne Huff, Mental Health Association in Michigan. It's my pleasure to host these two gentlemen, Nick and Kyle. I have the pleasure of working for what used to be called Michigan Protection and Advocacy Service from 2001 to 2006. A lot of people are not aware of the great work that the protection and advocacy system does. And I want to say that DRM, as it's now known as Disability Rights Michigan, has done a lot of fantastic work on behalf of people with disabilities in our state, and a lot of good work with regards to the public mental health system and looking for ways to improve the system overall. It's one of the reasons why we wanted to invite them today so that they could speak to the work that they've been doing and provide whoever's interested an update regarding their litigation. So I want to say thank you to both of them for being here today, and I'm going to turn it over to them. And what we will do is we will have questions at the last 15 minutes of this session. But as Kristen said, please put them in the chat. We will do our best to answer them. So I'm going to turn it over to Kyle and Nick.
Thanks, Marianne, and thanks, Kristen. Thanks, Mental Health Association, for letting us come through and talk a little bit about the litigation that we have going on right now. I'm going to try and share my screen right now, so I will look for nodding heads or shaking heads to tell me whether or not this works. And okay, let me see if I can get into the slide. And then let me get a display. So how do I look? Do you all see this? It looks good. All right, fantastic. So we're going to talk about a couple of cases that we have today, the settlements that were obtained, and give you all an update on what those settlements are, as well as give you a little bit of history for those of you who are unfamiliar with the cases. And we'll also give you an update on where things stand and what are the next steps moving forward on some of these larger, more lengthy cases that have been going on at the agency for a couple of years now. In addition to that, we've also got a couple, just a couple highlights on some current investigations that are ongoing right now with the organization. And so that's just to keep you all apprised of things that we're looking into, investigations that we're performing on, and the types of issues that we are looking into outside of the ongoing litigation that we have. So the first one that we're going to talk about is the DD et al. Versus MDHHS et al. Litigation. This is more commonly referred to as the KB versus MDHHS litigation because that is the original title of the lawsuit when it was filed back in 2018. But simply put, this is a lawsuit. This is a lawsuit on behalf of children with mental illness and developmental disabilities who have a need for but do not receive home and community-based services, and specifically intensive mental health services in their community. And so before we get into the settlement on this lawsuit, which was reached last year, we're just going to provide you with a little bit of the litigation background, how the case got started, when it got filed, what some of the major points in time on this case were prior to the case settling. We'll give you an overview of what the settlement agreement is, how it's going to work, how it's going to function, what are the core commitments that MDHHS has agreed to as a part of the settlement. And then we'll also get into a little bit about the implementation of this settlement that Ultimately, this isn't a settlement where money will be exchanged and the parties will go their separate ways. This is a settlement that will result in substantial systemic reforms to the mental and behavioral health system for children and young adults in the state. And so it will have some time-consuming components to it in terms of reaching the commitments that have been outlined in the settlement agreement, which again, we'll cover for you. So in terms of the background, we'll talk a little bit about who the plaintiffs are, who the defendants are, what the relief we were seeking in this lawsuit when it was filed. We'll talk about the interim agreement, which was reached prior to the settlement agreement, as well as the class certification process, which has already occurred in the case. So the litigation was filed in the Eastern District Federal Court in 2018. And this was a lawsuit that alleged that the defendant, MDHHS, and its director failed to provide the needed Medicaid covered services, mental health services to children in their homes and their communities. And so the plaintiffs asserted that a number of laws were violated as a result of this failure to provide services. And those laws include the Americans with Disabilities Act, the Section 504, the Rehabilitation Act, various Medicaid Act claims, as well as constitutional due process violations. And the 6 current plaintiff class representatives, as well as the former class representatives who were class representatives when the case was filed in 2018, share these common characteristics with each other. They're all under the age of 21. They're all Medicaid eligible. They all have significant mental, emotional, or behavioral health needs. They all require intensive home and community-based services to correct or ameliorate those emotional, behavioral, or psychiatric conditions, and they are not receiving such services. And so since this case is a class action, these plaintiffs' representatives are actually representing a much larger class of individuals. We estimate that this class is going to range in the state of Michigan in the tens of thousands of children that are going to meet this particular set of plaintiff characteristics. And all of those individuals are represented by the class representatives who are suing on behalf of this class and everybody who's similarly situated to them in the state of Michigan. The defendants are MDHHS, so the Michigan Department of Health and Human Services, and its current director, Elizabeth Hertel. Just briefly covering some procedural components of the case. MDHHS is the defendant because it is the single state Medicaid agency, and it's responsible for administering the Medicaid program in the state of Michigan. And Director Hertel was actually not an original defendant in the lawsuit. Whenever the lawsuit was filed in 2018, Nick Lyons was the director of MDHHS. He was since replaced by Robert Gordon, who was then replaced by Director Hertel. And those parties are automatically substituted out as defendants as the administrations change and new people are appointed as the director of that agency. The governor of the state of Michigan, in his official capacity, so Governor Snyder at the time it was filed, was also originally a defendant, but we made a determination that the governor isn't a necessary party to obtain the relief in this lawsuit. And the governor was dismissed as a defendant in this lawsuit a couple of years ago due to just the lack of need to have that individual as a defendant in the lawsuit. So the relief in this lawsuit really revolves around the principal rights that are being enforced through the statutes that were mentioned in the previous slides. And that right boils down to the rights of those class members to receive intensive home and community-based services in their homes and in their community, to not be required to go into institutional settings and out-of-state placement or more restrictive settings in order to receive the intensive mental and behavioral health services that they require. One thing that the lawsuit does not request is monetary damages. The lawsuit doesn't prevent anybody from who's a part of the class from trying to seek monetary damages as a result of any injury caused by the failure to provide services. But at its core, the lawsuit was seeking to create system reforms that would put the plaintiff's class in a position where they could access the services that they need. And in particular, those individuals who needed those intensive services, who were repeatedly going into emergency rooms, repeatedly having police contact, and repeatedly going into out-of-state placements in order to receive intensive behavioral and mental health services, to be able to get those in the most family-like setting, and ideally in their own family home, so they can remain a part of their community and they can access the things that they need to not be continuously going through a cycle of institutionalization throughout their youth and young adulthood. These rights are guaranteed by a number of federal laws, which we covered. And these home and community-based services include things like intensive crisis stabilization. So we'll talk a little bit more about the service array that was created by the settlement agreement. But ultimately, these are services that are meant to support you in your home and in your schools and in your community. and they are meant to provide intensive needs for individuals who might have a heightened need for these types of services, as opposed to maybe some of their peers who are also receiving Medicaid or Medicaid type services from other providers. So one of the big landmarks in the case occurred back in August 11th, 2020, and we reached a interim agreement with the defendants in this case. And ultimately, the interim agreement didn't really do much beyond put a couple chips in the pot in terms of making a commitment to try and resolve this issue. And it established a process by which the parties were going to negotiate a settlement in this lawsuit. And so after this happened, we were able to get out of a litigation posture in the lawsuit, and we're able to get to the negotiating table in order to try and craft a settlement that would resolve the claims of the class. And it also provided MDHHS an opportunity to get a jump start at trying to make some systemic reforms to the behavioral and mental health system that was serving children and youth in the state of Michigan. So it's important to note that this is a class action case. And so in a class action, you have the class representatives who represent the class as a part of the plaintiff class. And the relief that they are able to obtain through the lawsuit will benefit people who are similarly situated to them. So those people who have been harmed in the same way as them, and those people who have common claims in terms of the laws that have been violated resulting in that harm, there's going to be commonality in all of those individuals in the class. And any relief that the class representatives are able to obtain through their representation will benefit the entire class. So as I previously mentioned, we estimate that this is a very large class, again, in the tens of thousands by our estimates based off the data that we have. But we have those class representatives who are putting forward those types of injuries and those types of issues that they're having, and asserting that the issues and experiences that they have are common amongst people within the class across the state. So one of the tricky parts about a class action is that the parties cannot get together and just settle this case and agree to dismiss it. A class action is required, or it requires a judge to actually approve any settlement that is negotiated between the parties. And so one of the things that we'll talk about is the process in which a court can approve one of these settlements. But among other things, the judge is going to make a determination of whether this settlement is fair, reasonable, and adequate in order to resolve the issues that the lawsuit was brought in order to try and resolve. And after the parties reached an interim agreement on this case, we moved to certify this class. So to actually have the judge issue an order saying that we had a certified class and move from representing just those individual named class representatives to representing the entire class. And the judge did approve that class certification motion. So as we talk to you today, we have a certified class. We continue to have the class representatives as named plaintiffs in this lawsuit, but we have a certified class, and the class is defined, and that class was certified in November 3rd, 2022. And the class is defined by the court as all Medicaid eligible beneficiaries under the age of 21 in the state of Michigan for whom a licensed health professional has determined through an assessment that intensive home and community-based services are needed to correct or ameliorate their emotional, behavioral, or psychiatric condition. And after that class was certified, the parties continued settlement negotiations under the interim agreement and have now reached a final settlement agreement on the case. So we'll talk a little bit about the final settlement agreement, where it's at and what it does. We'll talk about it just to highlight a couple of specific provisions that I think are important just to note for individuals who are curious about what the settlement is going to do. We'll talk a little bit about how the state's going to provide oversight over this population of people. So again, Medicaid eligible kids under the age of 21 who have a need for intensive mental and behavioral health services in the community. And we'll also talk a little bit about who can benefit and how they're going to benefit from a settlement like this. So on January 17th, 2025, a settlement agreement between plaintiffs and the defendants was filed with this court in the Eastern District. And if this settlement is approved, then the settlement will resolve completely the plaintiffs and the class claims against defendants for that injunctive relief and the system reform. And the plaintiffs have moved for preliminary approval of this agreement. So in a class action, there's 3 steps to get to final approval. The first one is preliminary approval, where the plaintiffs will submit a motion for preliminary approval, and then the court will go through an initial determination of whether or not the settlement appears to be fair and adequate. So they're not approving the settlement at that point. They're just saying that they have enough info, or the judge is just saying that he or she has enough information to make a determination on whether or not the class should be put out, the class settlement should be put out for notice to the class, so that the court can hear from the individual class members and really anybody who has any kind of comment on the settlement, for good or for bad. That it opens up the case to comment and objections from parties that may be impacted by the settlement. And so that notice period will occur, and it'll be a set time period by which people can reach out to the judge directly and provide comments and objections to the settlement, as well as they can provide approval or can note favorability in the approval. But after the notice period is done, there will be a period of time in which the notice and comments will be responded to by the plaintiffs and the defendants. And after that particular point in time, there will be a hearing that will be scheduled in Detroit. And that hearing is called a fairness hearing. And after the fairness hearing, the judge will make a determination based off of all of the evidence that they have and all of the comments and the objections and all the briefing that's done by all the parties on whether or not the settlement is adequate and whether or not the judge will approve the settlement. And at that point, if the judge approves it, we will have final approval. The settlement will be in full force and effect, and we will be able to begin enforcing it and really begin the process of meeting the commitments within the settlement agreement. So the way that the settlement agreement works is the primary relief that is obtained through the settlement is the Michigan Intensive Child and Adolescent Service. So they're commonly referred to as MICAS because everything in this business is done through an acronym. And so that is the acronym for the service array that was created and is a part of the settlement. And it will also lay out some of the procedural and monitoring and contract-like related steps that MDHHS is going to have to take in order to ensure that class members are going to have access to these services within the MICAS service array. So if the court grants final approval of the settlement agreement, then MDHHS must develop an implementation plan laying out all of the necessary tasks and assigning responsibility for all of those tasks and setting reasonable timelines for completion to meet all of the commitments that are outlined within the settlement agreement. And most of those commitments are going to relate to having an adequate network of providers in order to provide these services, to have access to this service, to have timely screening, and I guess it just generally revolves around people getting what they need whenever they need it. And the service array is a bundle of services that will be available to class members once they are determined to be eligible for this program through those set screening and assessment procedures. And the MDHHS will be required to provide plaintiffs with annual updates until the exit criteria of this lawsuit, the exit criteria being the criteria in which they will be determined to have met the commitments made in the settlement agreement, are satisfied. And once the exit criteria are satisfied, then the parties will seek dismissal of the case because there will be no need for continuing federal jurisdiction over the settlement agreement for enforceability purposes, because at that point, the settlement will be complied with. So what it does is, again, it defines and makes available this comprehensive set of intensive home and community-based services in the MICAS array. And it's going to create those systems and procedures, not only used to identify, screen, and assess those class members for services, but also to ensure that they're going to get timely provision for those services. And it's also going to create quality management tools that are going to be designed to assess and determine whether or not the care that's actually being administered under the MICAS program is going to be of improved quality. And so there's a number of measures that are in there that are going to increase transparency into not only the data involved on judging whether or not you're running a quality program, but the quality care measures that are going to measure really where people are receiving their services, because ultimately, if more people are receiving services in psychiatric hospitals than there are in the community, then you're going to be moving in the wrong direction in terms of what the settlement agreement is seeking to accomplish. So what we really want to see is minimized out-of-home placements. We want to see whenever people are coming out of home placements that they're remaining in the community for a longer period of time. We're going to want to see whenever crises are occurring that they're being handled in the community, if they can be handled through services like mobile or intensive mobile crisis stabilization and intervention services that are part of the MICAS array. So there's a number of different ways in which you're going to monitor quality, but all of that we have things built into the settlement agreement that are meant to increase public transparency on how the system is working and how people are utilizing it. And MDHHS will oversee and monitor the implementation of this throughout the settlement agreement period. So in addition to improved screening and access commitments, again, the big thing is the MICAS array. And so the MICAS array primarily consists of these 6 services that are outlined on the screen. So intensive crisis stabilization services for kids. These are services that are meant to come directly to your child or young adult in the community while they're having a crisis. It's an alternative to calling the police or calling an ambulance to come and address mental health crisis in the community. And not only can these services be used to intervene in a crisis, but they can also be utilized to stabilize the crisis within the community, which will alleviate the need to ever have to call the police for that particular instance of a crisis or have to go into the emergency room, and is meant to be a preventative measure on having to go into a psychiatric hospital to handle every single mental health crisis that's occurring for the class. There'll also be intensive home-based services, and so this is kind of a more clinically backed, more detailed type of service than a community living support. This is a service that's going to be meant to assist your child or young adult with skill building. It's going to provide supports and assistance in getting that child out into the community and out of their home. And it's going to provide basic assistance with, kind of the activities of daily living that are necessary, and provide assistance and training to those parents who are continuing to live with and help their children manage and stabilize mental health, particularly whenever mental health is arising into a crisis situation. So in addition to that, there'll be care coordination and wraparound. We're hoping to improve the care coordination in the state by getting some better types of care coordination and case management services for the children in the class. We have respite care as a part of this service array. We know that respite care and the provision of respite care in particular is a really big problem across the state. Lots of people have respite in their plan, very few people actually get it. And so we wanted to make sure that respite care was a part of this service array, because we understand that getting parents and caregivers breaks is extremely important in making this work in the community. And in addition to that, parent support partners and youth peer support partners will be a part of this settlement agreement. And I can go ahead now and let you know that there's a lot more detail on this that we're not going to be covering, but it is available in Appendix A of the settlement agreement, which has details on the services, the description of them. They have criteria on where the setting they can be provided and will be provided. They have kind of more detail that we're going to have time to cover in this short period of time, but we'll be sure to get everybody a link to that if you have interest in looking in more detail about what these services are. And so there's also specific services about, there's also some specifics about expanded services for class members, so services that would be above and beyond what's currently available in the state. MDHHS will also be required to educate class members, providers, and public child serving agencies about the MICAS service and eligibility for them. So there'll be a number of commitments in the settlement agreement about developing awareness and communication tools to educate families about the availability of MICAS, the MICAS service array, as well as what the MICAS service array is about, and any accompanying due process rights that individuals will have if they have difficulties in accessing the MICAS service array and the way that they feel they should be accessing it in terms of the amount, scope, and duration determinations that are occurring within that service bundle. MDHHS will be launching a public-facing website on the MICAS service array to not only provide detail on what those services are, but also provide the public data on its progress towards ensuring that folks are getting the MICAS service array. And they'll also be updating beneficiary handbooks for the managed care plans throughout the state, which should trickle down to all of the CMHs in the state as well, regarding what MICAS services are, the eligibility for them, and how you can go about accessing them. And MDHHS will also, and already has made substantial progress in developing a statewide health tool to assist both in the MICAS eligibility, so for folks getting screened into the program to determine whether you're eligible for it, as well as to assess you for what specific amounts and types of services you're going to receive while in that program. And that tool is called the MHAM's tool. And so, for those of folks that are following along in the HHS policy bulletins, you've seen lots of policy bulletins on the MHAM's assessment tool. This is something that the state has actually made really good progress on rolling out and educating CMHs on, who are going to be the primary ones responsible for administering that tool. So that's certainly an area that even prior to the settlement being reached, the state was making really good progress on. And MDHHS is also going to be updating their access standards and eligibility criteria, developing annual targets to increase MICA service access whenever it's medically necessary as a part of the implementation plan to ensure that the settlement agreement and the commitments within it are going to be reached in a reasonable period of time. And there's also specific provisions for the timely provision of services and the specific goals of keeping kids in the community. And so MDHHS has already taken a lot of effort in expanding staffing and training the workforce on implementing the MICAS array. And that's included creating an entirely new division within MDHHS. The Michigan Children's Bureau of Coordinated Health Policy is a specific bureau within the state government who has been created to manage this My Kids Now program, which will be the program that will be responsible for administering and overseeing the MICA service array through their contracted managed care network. They're also going to be providing training and technical assistance to managed care entities who will be charged with providing the MICA service array through their various contractors. And they've undertaken a number of efforts to expand the provider network, which include maximizing the use of providers and paraprofessional teams as a part of that care coordination and a coordinated approach to providing mental health services to kids in the community, because kids go to different places. They go to school, they go home, and go into the community. And so it's extremely important that there's a coordinated approach to providing mental and behavioral services to kids in a lot of this MICA service array in the care coordination, and seek to facilitate that. And another thing that the state has already done is implemented medical education debt repayment program to incentivize more providers to get into this area and try to deal with some of the provider network issues and the adequacy of the current provider network in the state, and ensure that there are going to be enough people who have the appropriate expertise to provide these services within the service array. And then there's also going to be tools for evaluation and transparency. So under the settlement agreement, the MDHHS is going to be required to track the following data. I won't go through any of each of these individually, but I will highlight that the timeliness to access services is a really crucial component to this settlement agreement, that particularly whenever you're talking about intensive needs and crisis needs, that the time in which you can get that is one of the most crucial components to whether or not that service is going to work with you. So we've structured the settlement in a way where we will negotiate the specifics of those times, but have gotten acknowledgement that whenever these are crisis services, that they need to have extremely quick turnarounds on the timely, on the authorization and the provision of those services. And we'll also be tracking indicators that we would use to judge the success of the settlement agreement, such as changes in living environment, particularly related to hospital level of care treatment options. And so we want to know where kids are receiving these services and for how long they're able to receive those services in those settings. And that's going to be a really big measure of the impact of this particular lawsuit, because again, the goal is receive these services in the most family-like setting. And so a lot of these services really seek to prevent institutionalization of any of these kids and allow them to remain and continue to remain in a community-based setting, and ideally with their own families. So some more things on the state oversight and monitoring of the settlement implementation. MDHHS is going to be responsible for managing their managed care or monitoring their managed care entities for compliance. And this is going to include data reporting that's going to occur from the PIHPs in the state at regular intervals. And they're also going to be updating statewide guidance documents to include the MICAS assessments, so that those prepaid inpatient health plans have adequate information on what their responsibilities are going to be, and ensuring that the terms of the settlement are going to be complied with. And they'll also be reviewing and revising these managed care contracts over the course of the implementation of this to ensure that those obligations are contained within the contract, and the obligations will be imposed upon their managed care organizations, not just through the federal law, but through that contract that MDHHS is going to have with that contractor. And MDHHS will also be establishing an advisory body to advise on the performance and data and quality benchmarks for the MICA services array. And we'll be able to advise MDHHS on best practices and provide feedback to MDHHS throughout the settlement implementation process. And that advisory body is going to include not only behavioral health providers and provider representatives, but it's also going to include children, youth, and family with lived experience in the Michigan's children's and behavioral health system. So there are built-in components to make sure that the people who are providing this service and the people who are receiving these services are going to have input in the settlement agreements implementation and will be involved with that throughout the implementation process. And another get in the settlement agreement, or another form of the relief that was obtained in the settlement agreement, was some clarification on some due process rights that individuals have, just as Medicaid recipients, but particular to these class members. Most of these are things that you should expect out of any Medicaid system in terms of if you request a Medicaid service and is denied, you should be receiving written notice explaining to you that it was denied and giving you the reasons why it was denied. The same if it is reduced or suspended or terminated. That should be common. We see that a lot. Some CMHs do a good job with this, some don't. But one of the biggest problems that we've encountered in the state is whenever everybody agrees what you need and it's in your plan, it's authorized, nobody's disputing what the amount of that service is and the duration of the service is and what the scope of that service is, but you simply can't find a provider to get it for you. So therefore you do not receive that service. The settlement provides due process protections for that specific instance, where if a class member is assessed and determined to need MICA services, but the services are not provided in a timely manner, they will be entitled to notice explaining that they have a right to appeal that and to seek relief to obtain that service. And that's been a very challenging due process issue for both kids and adults over the course of a number of years. And we think that that's going to be a really important part of the due process protections that the settlement provides the class members. So the people who are going to benefit from this settlement are going to be those who fall under that class definition that we previously mentioned. And the MICA service expand currently existing services, and they also add some new services that didn't used to exist a couple of years ago prior to filing the lawsuit. So the new service, and probably the biggest one, would be that mobile intensive crisis stabilization services that I mentioned earlier. That was something that you just simply couldn't access depending on where you lived in the state and in most counties. And that's a really crucial missing component to our mental health system for children, because again, this is going to provide you with an option outside of police intervention, outside of going to the emergency room. And this is going to be teams of people who are mental health professionals responding to mental health crises who should be familiar with your care and can respond to where that crisis is occurring. It's going to expand a couple of services that already exist. And so intensive home-based services, we're very hopeful will be an expanded type of community living supports that'll be more beneficial to the class members who can receive it. We're trying to improve some services that already exist, like wraparound. We have found a number of problems with the way that wraparound is administered across the state, and we think that the settlement is an opportunity to improve the use of wraparound. And then there's going to be some additional oversight for all of these services, including respite and these youth and parent supports that may not be available to you depending on where you live in the state. And all of these are meant to provide better opportunities for kids to remain in the community and remain in their family home and avoid out-of-state placements. So the implementation has a couple components, which I'll cover really quickly. But the agreement will be considered complete once the defendant, MDHHS, has met the exit criteria, which the case will be dismissed, and that will be determined by MDHHS being substantially in compliance with, again, that exit criteria, which is laid out in the settlement agreement. And ultimately, what the exit criteria is the criteria in which the commitments that have been made in the settlement agreement to boost access to this service array and ensure provision of the service array to the class members will be met. And so, among other things, MDHHS is going to have to establish and expand this MICA service array to meet the availability to children and young adults across the state. They're going to have to establish the foundation for timely statewide provision of MICAs to class members to minimize out-of-home placement. establish eligibility criteria for MICAS, implement standardized statewide functional behavioral, a standardized functional behavioral profile for eligibility and service determinations, as well as publish due process rights of class members to receive ABDs, adverse benefit determinations, and revise managed care contract language as required to meet those goals. And there are certain factors that MDHHS cannot control that can have an impact on whether or not this settlement or the exit criteria can be met. Some examples of those would be the court approving the settlement agreement. Obviously, we're talking to you at a point in time where we're seeking preliminary approval and have not yet obtained final approval. So until the judge gives us final approval on this settlement, then we cannot begin an implementation plan or begin to reach the exit criteria unless it's done voluntarily. And then the Michigan legislature is going to have to appropriate sufficient ongoing funding to MDHHS to allow this to happen. All of these things take money, and we need the legislature to appropriate money. And so at present, we have received about a $91 million appropriation from the state for the last couple of years while the settlement was being negotiated, in order to begin some of these changes, like the development of the Michigan assessment tool and some of these other things that the state is making progress with already. And so we have seen the legislature appropriating the funding that is needed to begin making some of these changes, and we are very hopeful that they will continue to provide us with that funding. But obviously, that's something that we can't necessarily control. And then the Center for Medicaid Services will also have to approve any of the waivers or demonstration authorities that are going to occur to make these changes happen, as well as any of the amendments to those managed care contracts and any rate adjustments that are going to be necessary to ensure that there's appropriate funding going down to these services to ensure that people have adequate access to them. And it also, people are going to have to remain eligible for these for Medicaid coverage in Michigan. So if you leave Michigan and you establish residency in another state, you may not be a class member in the Michigan Medicaid class action anymore because you will no longer have Medicaid eligibility. And in the event that any of these contingencies are not met, the settlement agreement contemplates that and requires the plaintiffs and defendants to engage in good faith negotiations to modify the settlement to account for any of those contingencies. Basic timeline of where we're moving forward from here is as follows on the screen. Like I said, we've already filed a motion for preliminary approval. Assuming the judge grants preliminary approval, we will then issue the notice out according to the notice plan. And once that notice goes out, we've asked the court for 60 days to allow for comments and objections to come into the court. After that 60-day period of time, we've asked for 3 weeks in order to do some supplemental briefing so that we can address whatever those comments and objections are that come in, both the plaintiffs and the defendants separately. And then after that, there'll be a final or a fairness hearing in which the judge will make that ultimate determination on whether or not the case or the settlement agreement will be approved. And then assuming approval, we'll begin creating and implementing an implementation plan, which is contemplated by the settlement agreement. There'll be annual reports by MDHHS, which will go to the plaintiffs, as well as will be posted on that public-facing website that we discussed, or at least a bulk of that information will be posted on the website to the extent that it doesn't contain private personal identifying information and some things that they wouldn't be allowed to post publicly. But the agreement contemplates an implementation to be completed in December 31st, 2029. And so assuming that were to happen and they would substantially comply with all of the commitments and meet all the exit criteria, then the case would ultimately be dismissed. But obviously, we're talking about the future and very well out into the future. And so this is just take it a step at a time at this point. This is where we're at. We're going to continue to keep the public appraised of the lawsuit on our website so that folks know what's going on and what the timelines are. But at this point in time, until we hear from the judge on the preliminary approval motion, we are just waiting, but we are prepared to begin issuing notice as soon as that happens and are very hopeful and frankly confident that the judge will eventually get to this motion and will preliminary approve it so we can begin to take the next steps. So with that, I'll go ahead and turn it over to Nick.
This is a case that Kyle and I filed nearly 10 years ago. It's been around for a long time. The thing that led to the lawsuit is even older. It goes back to 2015. So this was a Washtenaw County problem, which arose when the predecessor to Washtenaw County Community Mental Health had a budget deficit. And to save money, it changed the way that it calculated self-determination CLS budgets for individuals on the HAB waiver. So this was always about a specific service delivered via self-determination for a specific population. And it was only in Washtenaw County. And what happened was they used to calculate these budgets by taking an hourly staff rate and multiplying it by the number of units you were approved for, and then adding in the costs of activities. So if you went to the bowling alley once a week, that would be considered a cost and added, and then your transportation costs would be added as well, and things like that. And the budget would be built up based on your plan of service and your individual needs. What they started doing was they started using an all-inclusive rate, which was based on a frozen hourly rate multiplied by the number of hours. The new rate was $13.88, I think. And people were put in the position of having to fit their whole plans of service into that rate, which nobody, or at least very few people, could do. This was May 2015, and we filed the case in March 2016 after we pursued hearings for some of the plaintiffs. Actually, the original plaintiffs, there were three. There's four now. And the Washtenaw Association for Community Advocacy, which is the local ARC chapter. The ARC chapter was representing the interests of its members who were self-determination CLS HAB waiver recipients. We had three defendants. The Department of Health and Human Services, of course, because it's responsible for Medicaid in Michigan. And then we had the regional prepaid inpatient health plan, and we had the local CMH, because all were, in our view, responsible at some level for the thing we were complaining about. We litigated this case for many years. It went to the Sixth Circuit Court of Appeals twice. We had something like 1.5 million pages of documents exchanged, 20 depositions, 30 subpoenas. It was grueling. And then finally we reached a settlement agreement with the state, which was the result of almost a year-long mediation. The settlement agreement was only with the state. So the two local defendants, the PHP and the CMH, didn't. There were two main forms of relief in it. One is these statewide fee schedules. And the basic idea is that if contingencies are met, all of the self-determination CLS HAB waiver people in the state would get $31 an hour to pay for their services, and that would be adjusted for inflation over a number of years. And then the overnight health and safety service would also get a bump and be 70% of the CLS rate. The contingencies for that are the legislature appropriating enough funds, CMS approving anything it needs to approve, and the Region 6 PHP signing a contract, which it has not done yet. Too early to say what'll happen, but that could be the failure of these contingencies. The good news is, if that doesn't happen, we get what we call the secondary relief, but really is what we were asking for all along in the case, which is costing out budgets the way they did it in Washtenaw County before the change. There's this thing called Attachment C in the settlement agreement, which will become Medicaid policy in the provider manual, which will say that the budgets have to be built up based on each person's plan of service, just like they used to do it. I've covered this, but this is an estimated cost of the fee schedules. It would be over $100 million. And there is a line item in the budget right now for these appropriations. Unfortunately, like I said, the PHP hasn't signed a contract, so that it could all be for naught. But there is an attachment A, which is on that slide, which clarifies the scope of CLS. And then there's an attachment B. Sorry, go back. I'm not controlling the slides, by the way. So, all right. Attachment B, which clarifies medical necessity. And this is really important. Amount, scope, and duration is the basis of the CLS service and the budget you get. The Washtenaw CMH, and I think other CMHs, have always taken the view medical necessity is the number of hours, and that's it. One thing that we've done in the settlement is clarify the scope, which is what the service actually does. And so if somebody goes once a week to the bowling alley to bowl for community inclusion, that is an activity that's part of the medical necessity and has to be accounted for. We also have provisions that require person-centered planning the way it's supposed to happen. real discussions with beneficiaries during the person-centered planning process about what their needs are, what they do, what they want in their plans, and a specific discussion of the cost of all of those things. One thing that happened with the old budget method was that CMHs would send people to fiscal intermediaries when they couldn't make the all-inclusive rate work, and the fiscal intermediaries would say, well, you could, go to the bowling alley, but in that case, you're going to have to pay your staff less. Those were decisions that affected the amount, scope, and duration of services that only the CMHs should have been doing. And so this will go into the Medicaid provider manual and make clear that the CMHs have to engage with these things in person-centered planning. There are protections for self-determination. One thing that's really significant is there are notice and hearing rights now with self-determination terminations. That was never the case before. So if you are facing that, the CMH has to give you an advance notice, and if you requested an appeal timely, then you have a right to continue with your self-determination arrangement until a hearing decision is issued. There are a couple of provisions that were framed in the settlement agreement as Region 6 PHP specific things. One of them is complying with ALJ orders. Except for that one, if the PHP doesn't sign a contract, everything else that's PHP specific will become Medicaid provider manual policy. One of those is you have to let people have the choice to self-determined services, and also meaningful notice of budget or service reductions. And there are two parts of this. One is giving a really specific reason for the reduction, and also saying in writing what was not approved that the person requested. A lot of times we were dealing with situations where the person would go to the PCP and talk about all these things they wanted, and the CMH would deny them, but never formally deny them. And so there was no record of it, and there was no record of everything the person said in support of that. And so it made going to a hearing difficult. Now that all has to be documented, which should make hearings better. We've had a problem in Michigan for a long time that we've called the hamster wheel problem, where somebody goes to a hearing and they say, I need 10 hours instead of 5 hours, and the administrative law judge agrees. But instead of issuing an order requiring the CMH to provide 10 hours, the administrative law judge issues an order telling the CMH to go reassess the person. And so the CMH goes and reassesses and awards 5 hours again. And technically they've complied with the order because the only thing the order required was for them to reassess. This fixes that, at least for the HSW self-determination, CLS and OHSS population. But as a practical matter, now that the hearing system understands it can and should be doing this, I think this will extend beyond the population at issue in the lawsuit. In short, now the ALJs can order the CMH to provide a specific number of hours or a budget. And of course, the person has to prove that they're entitled to that at the hearing, which is not necessarily easy. But if they do, the hearing system will work the way it should. The settlement approval process took a long time. The settlement was signed in December 23, and it wasn't approved until December 11th. That was because all of the CMHs and PHPs opposed it. Thankfully, almost everybody else supported it. And the court ended up, after extensive briefing, approving it on the record at the hearing in December, and the consent decree issued on January 27th this year. March 2nd is when the provisions went into effect. So most of the policy things, except for the costing out thing, are in the works right now. The state has talked about putting those in the May update to the Medicaid provider manual. We think they should do it sooner, but that's in progress. It's too early to say whether the contingencies will be met for the fee schedules. We have a June 1st deadline for that, which can be extended. As I said, the Region 6 PHP hasn't signed a contract yet, but it's not clear whether it will. And if it doesn't, whether there might be some other way to get the fee schedules. Okay, that's it for Waskul. Just very briefly, we're doing a couple things right now. These aren't in litigation yet, but one thing we're very interested in is disabled adult child Medicaid eligibility. This is something that comes up when somebody is disabled before the age of 22, they get SSI, and then they start collecting on their parents' RSDI. And the SSDI, RSDI that they receive causes them to lose their SSI eligibility. And so they're not eligible for their SSI related Medicaid. But at that point, federal law and state policy requires the department to evaluate them for other Medicaid. And one of those other Medicaid categories is called DAC, Disabled Adult Child Eligibility. The problem is that Michigan's computer system does not automatically do that. And so they have to manually screen everybody. And a lot of these people get missed. So if you know anybody who's experienced this, or if you know somebody who knows somebody, please let us know. Pediatric private duty nursing, essentially, Michigan has caps on the number of hours you can get for kids who need these services. We don't think that's legal. Failure to provide. The investigation has concerned Network 180, but this is really a statewide thing. This is when somebody has a service approved in the plan, but it's not provided because the CMH says we don't have providers. We're interested in hearing about anybody who's dealt with that issue as well.
Thank you, Nick and Kyle. Like I said in the chat, people can stay on. I want to give time for questions. That was incredibly comprehensive and helpful, and a lot of work on your part. So thank you for sharing all that. So I want to go through, first I'm going to start with the chat, and then we'll go with questions that people in the audience have. Let me kind of go through here. One of the questions was about funding. Basically, where's the money going to come from? And then, so let's start with that, and then we'll go to the next question.
And this is related to suing the state, or the
Yes,
Yeah.
this goes back to the old KBDD case.
Yeah, I can answer this unless you want to. Kyle.
No, go ahead. I mean, it applies to both cases, I guess.
Yes, it does. So I have to give background to answer this, and it's legal background, which probably won't make sense to anybody. But basically, the 11th Amendment to the Constitution has been interpreted to mean that states can't be sued by their own citizens in federal court. They have immunity. There's a way around that, which is called the Ex parte Young Doctrine, which says that if you sue an official, the director, almost always, of a state agency or the governor, in the case of the state of Michigan, you can proceed against them in their so-called official capacity as if you were proceeding against the entity itself. If you do that, you can only get prospective injunctive relief, which means you can't ask for anything that's financial related. You can have incidental financial expenses as part of an injunction or a declaration, but you can't do it directly. And the Sixth Circuit case law is very specific on who that defendant should be, and it has to be somebody who's very closely tied to the agency that's in charge of the thing you're complaining about. In the case of KB and in the case of Waskul, that's the DHS director, because DHS administers the Medicaid program. In terms of the relief you can get, it wouldn't have made a difference anyway with the governor, because you could only get declaratory injunctive relief against him too. Aside from all of that, federal courts can't order state legislatures to appropriate funds. It's related to immunity, and it's also, there are federalism issues, there's separation of powers issues. So what you end up with is a case like ours, and if you end up with a settlement like ours, you can require certain things to happen that are in the department's control, but the department can't control the legislature. So that will always have to be a contingency. But like Kyle said, we have appropriations that are ongoing for the KB settlement. And if the contingencies are met in Waskul, we'll have that funding too.
Yeah,
Thank
because of
you.
the limitations that Nick had just mentioned, you tend to focus on the what, not the how, in terms of the funding. And so ultimately, the funding could come from the federal government in terms of the Medicaid program allotment. It could come from any kind of tax source. But for the reasons that, again, Nick mentioned, we have some restrictions on ordering the legislature to order specific amounts of money. And we just want to focus on what judges can order, which would be the provision of federally mandated Medicaid services to the class.
Yeah, and when you're doing federal litigation like this, you're operating within the bounds of a lot of constraints, and it's just, you do what you can.
Yeah, thank you. Another question, is there a timeline for approval of the settlement and implementation and monitoring?
Well, on the KB litigation, it really depends on when we get the preliminary approval. I went through a couple of the dates and timeframes that will start to run from the date of preliminary approval. So we'll have a 60-day notice and comment period. We'll have some additional 3 weeks, ideally, to be able to do some briefing. And again, all of this needs to be set by the judge, and we should be able to know what that timeline will be if and when we get the preliminary approval on that motion. So I can give you the rough idea of that, but until we get the order from the court, it's going to be really hard to give specific dates and timelines.
Thank you. Regarding, what we know as KB, will there be an increase in SED waiver slots?
Well, I think that one of the points of the settlement is that we don't think it's appropriate to box kids into certain waivers in order to obtain Medicaid services. That ultimately, if you participate in the Medicaid program, then you're entitled to the covered services which are medically necessary for you. And the notion that you need to be in this silo or this waiver or have to fill out this paperwork in order to get these things is kind of contrary to the underlying purpose of the Medicaid program. So whether or not it would increase slots for the SED waiver, I don't know. But what I do know is that if you're in the My Kids Now program and have access to the My Kids service array, then it doesn't matter whether you're on a specific waiver. You just need to be Medicaid eligible because that's the condition precedent to receiving Medicaid services.
Yeah, and as a matter of EPSDT law, waiver limits can't limit the amount of services that you get under the state.
They can't have specific waiver slots for SED waiver under the waiver application, is my understanding. So you can't have caps on that waiver as you can, and maybe like a half waiver or some of the other waiver programs that allow that.
Another question is, how is it that administrative law judges are able to terminate a self-determination arrangement?
Well,
are they able to do that?
No.
No? Okay.
We're talking about CMH's terminating self-determination arrangements. And until the settlement happened, you couldn't do anything about it. The self-determination guidance expressly said that termination of self-determination arrangements were not subject to fair hearings. And so you couldn't go to a hearing to contest it. Now you can, and an ALJ can reverse it and make them keep giving it to you.
Any word on 2 questions about Waskul? Any word on CMS approval of Waskul? And when do you anticipate that the Waskul settlement will go into effect?
Well, it's in effect right now. And some of the policy provisions are slated to be released within the next month, hopefully. As far as the fee schedules versus the costing out thing go, we don't know. The deadline for that is June 1st, which could be extended. And there's too many moving pieces to know which way that's going to go right now. Our named plaintiffs are getting the higher rates right now. That's part of the settlement agreement. The 4 named plaintiffs, they're getting funding directly from the state under the settlement agreement to implement their plans right now. But relief beyond that hasn't happened.
Thank you. And then one more question from Kate Dahlstrom. You have your hands up?
I do. So Do you ever present this information to legislators? For instance, right now, in fact, even right now, there's a hearing, I think it's a budget hearing for the appropriations, the state house appropriations. People in agencies are making requests for money for the fiscal year 26 budget. Legislators need to know this. And we had a couple of bills in the last session that would have increased the behavioral health workforce. There was one regarding the social work exam. I think there was state reciprocity. There's things like that will, help actually implement all these settlement agreements that our legislators need to be aware of. Like they could pass that exam modification for social workers, and they need to know this stuff is out here. And I believe, unless you're already doing this, that most of them don't have any clue what's going on. And now is a really critical time because they're debating, the next year's budget.
Yeah, well, agreed in general, and the need to raise awareness. As far as these lawsuits go, they are aware. For KB, they've already appropriated on an ongoing basis. For Waskul, there is a budget line item already. And our understanding is that they are aware of these settlements. They do intend to fund them.
The funding you thought was what, 90 million? Is that even close to being, or was it more?
90, I think it's $91 million a year, and that's just for the KB settlement.
Yeah, and Kate, I think that once we get into a point where we have or if we get to a point where we have an approved final settlement agreement and a beginning implementation, the determination on how much money is working, we can utilize the data that's being collected at that point, and we can come to better determinations on more or less, or what the appropriate amount of money is based off of the data at that point. So, but we do know that the legislature is aware of it. The legislature has been funding these cases, and so we tend to try to avoid lobbying, I guess, to some extent, in terms of telling legislators how to specifically act on bills as it pertains to litigation that we're actively involved in. But point taken. I mean, I think it's a fair point to say that.
Yeah.
Thank you.
I think it's a matter of
Thank you.
education, especially with regard to, behavioral health workforce. Thank you.
Yeah, thank you. Thank you for the questions. I'm going to wrap up in a minute. I want to thank all of you for joining us, and I really want to thank Nick and Kyle, not only for their work, but for joining us today. Before we wrap up, I do want to mention that MHAM has a MyAble webinar on April the 8th to talk about MyAble accounts. And also I want to let everybody know that the Mental Health Association in Michigan, we have memberships if you're interested in getting our electronic newsletter that has a lot of mental health related public policy updates. You can check out our website. They're real affordable. Our main focus is on mental health public policy, particularly at the state and local level. But as you can all imagine, one of the things that MHAM and a lot of people on this call are really paying attention to is what's going on federally with regards to the proposed cuts to Medicaid. So if you want that kind of information, it might be beneficial for you to check out our memberships by all you have to do is put in the browser, Mental Health Association in Michigan. We have a new website. It gives you lots of information. So again, I want to thank everybody for joining us today. Again, thank you, Nick and Kyle. And I hope that you all have a great rest of your day, and take good care.